for having me. I'm Lorelie Brannan, and I'm your county judge. I have been judge for over 2 years and have served the community during that time. I am seeking your vote to remain Baker County judge. I am committed to the Constitution, the rule of law, and fair treatment for all who interact with the court system. I am the first female county judge in Baker County history. I preside over hundreds of county court cases, including civil, criminal traffic, criminal, small claims, landlord-tenant, civil infractions, as well as municipal and county ordinances. I also handle underage vaping through my tobacco court. I handle daily first appearances and warrants, and by special assignment, I preside over circuit court matters in shelter hearings and resume the truancy docket after it came to a halt during the recent pandemic. In addition to holding regular court dockets, I also manage administrative responsibilities. After our longtime county judge retired, I became your judge through a process called the appointments process. I submitted a 71-page application and went through 3 interviews in order to become judge. 1 interview here at the local level with the Judicial Nominating Commission, an interview in Tallahassee with a panel of deputy and assistant general counsels to the governor's office, as well as an interview with the general counsel to our governor. At the conclusion of the process, the governor selected me to fill the position of county judge. At the time of my appointment, I was a career prosecutor, having served for over 14 and a half years as an assistant state attorney. I worked here in the Baker County office since 2008, handling hundreds of cases representing the interests of the state of Florida and of victims of crime. The skills, experiences, and training I have as a former prosecutor have laid a strong foundation to my service as county judge. I have worked not only as judge to continue holding regular court dockets, to address the cases that come into our system, but to also improve upon the processes and be efficient in the administration. I have also worked hard in the last 2 years that I have been on the bench to create outreach programs intended to educate both students and adults on the role of the courts. I love the law and I love sharing it with others. I am invested, experienced, and fair.
Hello, thank you for having me. I am Julie Cruz Johnson, and I am asking for your vote in the upcoming election in August for Baker County Judge. I believe that I have the education, the experience, and the commitment to Baker County to serve as your next Baker County Judge and to serve well. I am a lifelong resident of Baker County. I attended the Baker County High School and graduated number 2 in my class as salutatorian. I then went on to the University of North Florida and received a degree in economics and criminal justice, summa cum laude, with a 3.96 grade point average. I then attended the University of Florida College of Law, where I graduated number 10 in my class with honors. I have been an attorney, and a member of the Florida Bar for the last 24 years. The last 21 years of that time frame, I have served as an integral portion and played an integral role in our local criminal justice system as a public defense attorney. In doing so, I have represented thousands of clients who have been charged with both criminal and mental health matters. And in doing that job, I have held the state to its burden of proof. I have learned the law, I've learned how to interpret the law, and to break that law down with effective communications to allow my clients to make informed decisions about the outcomes of their cases. I'm familiar with the law, I know the law, I'm able to explain it, and I expect and will also offer a role in the criminal justice system as your judge in treating everyone fairly with dignity, civility, and kindness while giving people the right to be heard in the courtroom. In addition to my 21 years of service here to Baker County and my lifelong residency here, I am also a wife, a mother, I'm a Sunday school teacher, I am in charge of the Sunday school classes at our church, and I am also a proud Rotarian who is committed to giving back to this community through community service. I believe that I do have the education and the experience in the courtroom, and that I am committed to this county, and that I am fair and right for this job. As an assistant public defender, I too know the ins and outs of the courtroom. I know how to be professional. I know how to give respect and to demand respect. And I intend to carry those traits through to serve you as your Baker County judge. This is my county. You are my people. I am uniquely qualified because I am a lifelong resident here. I understand the needs and wants of our community, and I feel that I am up to the challenge of serving you as your next Baker County judge. Thank you.
What are your top priorities or things you would like to accomplish in your first half of your term if elected?
If elected, my top priorities would be to ensure equal access to the judicial system for all. I believe that people need to feel that they have the right to be heard. I have stood in front of judges where I felt that the judges were not listening to everything that was being presented. And I've also stood in front of judges where I felt like the judge was giving equal opportunities to both the state and the defense to be heard, and then making a well thought out and reasoned decision in cases. And I believe that even if the judge does not come down on the side that the party would like, if the person has had the opportunity to be heard and to have expressed themselves, they are better able to understand and respect the judicial decisions. So I hope to ensure that there is equal access and that every party has the right to be heard. And I hope to be able to use the process with efficiency and timeliness so that people aren't waiting for months on resolutions. I understand that some cases, especially criminal matters that are very serious, may take longer times than others to resolve. But I think that there are other matters that could be dealt with quickly and efficiently to give someone their day in court. I also believe that one of the things that needs to be improved upon is the respect for our criminal justice system. And I believe that people need to understand that when they come into the courtroom, it doesn't matter who they know, the color of their skin, whether they're male or female, or how much money that they all have equal rights to be heard. And I believe that that's one of the issues in our criminal justice system, is that the feeling of the lack of being heard and the lack of respect, and that is something that I would try to increase and improve upon within the first half of my term, is giving that respect, allowing people the opportunity to be heard, and also in the process improving our reputation.
Thank you. I would like to continue to improve upon the processes that are in place now, which I have been working on for the last 2 years. I will tell everyone that as a former prosecutor, it was my job to enforce the laws of the state of Florida as a member of the executive branch, but it was also to enforce them fairly. And so part of my background is evaluating cases, strengths, weaknesses, and applying those facts to the law, and making sure that cases that are brought to court are cases that could be proved beyond a reasonable doubt, because that was the state's and is the state's burden. And so I have the experience in evaluating cases and looking at them from both perspectives, from both sides. There were many a time that I would receive a case, interview witnesses, look at evidence, talk to the officers, and that case would never make it into the court system because there was not sufficient evidence to move forward. And so the prosecutor is actually the first line of defense of the Constitution, because the state has the burden of proving the case beyond a reasonable doubt, and ethically can only bring cases to court and to trial that they believe can be proven. And so I have the experience of treating people fairly, and that is something that I have always done, first as an attorney and now continue to do as a judge. And that is one of my priorities, is making sure that people feel that they have been heard, that they have been treated fairly, and that they have been treated with respect. I know there may be some times that people are in court and it appears that based upon the facts as well as the law that the ruling is clear for one side. But I still make sure and I allow both sides to have their say, to be able to feel like they have been heard and that I have considered what they have to say, because there may be something that they have in the information that's not been placed before the court yet, and that could make a difference, or it could change the ruling or perspective. And so that is one of the most important aspects of being a judge, is making sure that people are treated fairly and being heard, and I will continue to do so.
Also, as a public defense attorney, I too have to evaluate both sides of cases. I have to know what the state has to prove beyond a reasonable doubt so that I can do my job and defend my client, and to have a discussion with both the state as well as the court and the jury system should the case go that far. There have been many times where I had to approach the state attorney's office and say, here are these additional witnesses, here is this additional information that you do not have. So I don't want anyone to think for a minute that my background as a former or a current public defense attorney means that I know the law less, or that I am unable to evaluate the strengths and weaknesses of cases, because that is exactly what I do on a daily basis. I also have a reputation for treating all people, victims, witnesses, and clients with respect, dignity, and civility.
What prompted you to seek a county judgeship?
Well, first I'll say that from a young age, I knew that I wanted to be a lawyer. I wanted to help people. I wanted to uphold the law. I believe in our system of government as well as in the rule of law, and we are a society of laws. Without laws, our society breaks down and chaos can ensue. And so that's been an important aspect of my upbringing. I had a very strict upbringing in my family, and so that carried through as far as my personality and the personality traits that I have. So I'll tell you that I wanted to be a lawyer to help people, and as I grew through high school, volunteering at the state attorney's office and moving into college, I knew that I wanted to be a prosecutor. And so I took courses and proceeded on a path in order to gain that particular job as my career, to be a prosecutor. That was my original goal. As I've worked and grown up through the court system here in Baker County, I have gained skills and experiences that when our county judge retired, I believed at that point that I would be an asset to the bench and that I could utilize those skills and experiences to the benefit of our community as well as to the benefit of the law. And so it was a progression as far as my wanting to become a judge. It wasn't something that I necessarily set out and then took steps to then accomplish. And so everything that I have done in my career has been done because I genuinely care about our community, I care about the law, and I care about giving back, and that translates now into my being the judge.
I have a servant's heart. I have always been interested in the law from a young age as well. It was always my desire to serve others in some capacity. I became a criminal defense attorney upon graduating from law school. I had applied at both the state attorney's and the public defender's offices, and this was the job that I found. And I love my job because I do have a love and a respect for the law. Even early on, though, before becoming an assistant public defender, it has always been my desire to be the Baker County judge and to serve our community in that fashion. I believe that the experiences and the education that I have and the commitment that I have given to Baker County speaks for itself. I have treated all of our citizens with respect and kindness. I know how to communicate with people, people of all different backgrounds, of all different ethnicities. And I believe that that experience translates well into me becoming the Baker County judge. It's been a lifelong goal of mine. I truly love the law. I love the people of this community, and I believe that I can be an asset to our community. I too applied for that appointment from the governor's office, and I did so because I thought I had things to offer this community and that I had the skills necessary to excel in the job. I still believe that I have those skills and assets, and I hope to be able to sit as the county judge and to show the community that I understand its needs and have the ability to carry through. I believe that through that appointment process, I was very well thought of locally. I had lots of support, emails, phone calls, letters that would be written on my behalf to the to the governor, but I feel like the citizens of Baker County went unheard, and I believe that this election is the opportunity for the citizens of Baker County to make their decision as to who should sit in this chair and serve as their Baker County judge.
Okay.
I would like a quick rebuttal.
You want to? Okay.
Yes, ma'am.
You got it.
1 minute.
All right. Go ahead.
Thank you. I wanted to educate the citizens that the appointments process is a process that's governed by our Constitution as well as our laws to fulfill a judicial vacancy. And so there is a process that is in place, as well as a judicial nominating commission that's appointed by the governor to vet candidates as far as their applications, as well as interviews, in order to ascertain their judicial philosophy as well as their qualifications to be a judge. And I want everyone to understand that I went through that process sincerely, genuinely, and I had the support of people in our community who wrote letters on my behalf as well, who are references on my application. As well, I would like everyone to know that the interview process was rigorous. There were multiple discussions within each of the interviews about judicial philosophy, as well as statutory construction, Supreme Court cases, philosophies that we had related to interpretation of the law. And so it was a rigorous process that I went through in order to become your judge.
What do you think are most important skills needed for a good county judge?
I believe that the most important skills needed for a good county judge are the ability to listen, to keep an open mind, weigh all of the facts of every case or situation that is before the court, apply the law to that, so you need a knowledge of the law, and then you're able to reach well thought out and well reasoned decisions that are in line with the law. It's not the judge's job to insert personal feelings into a case. Those should be set aside, because personally, a judge may not always agree with the law that is written, but it's our job as judges to set those feelings aside and to follow the law as it is written and to apply that to the facts before you. It's also important to have the person have an opportunity to be heard. And by person, I mean both parties equally in a situation, and to know that they are being heard, that they are being listened to respectfully, that even if you don't agree with them, you have considered what has been said, and in doing so you create that open access to the judicial system, and you're treating people with civility, dignity, and respect. So I believe that those are all very valuable traits, and I believe that I possess those traits and have the ability to use those traits to do a great job as your county judge.
I believe that a judge needs to have good analytical skills as well as a working knowledge of the law in order to be able to evaluate the facts that are presented by both sides and to be able to consider arguments that are presented by both sides. Many a time when I was in court as an attorney, as well now as a judge, I would listen to arguments by someone from my office from the state, as well as arguments by a defense attorney, and I would say, that's going to be a hard decision for the judge, because they're both very reasonable in what they are asking for and in what they are presenting to the court. And so the court having a knowledge of the law is very important to be able to weed through and select through the information that is going to be pertinent to the law that's being sought to be applied, whether that's the law of suppression, whether it's sentencing, or some other aspect for a case. And so I believe that knowledge of the law is very important, as well being able to keep an open mind in hearing a case. I will prepare for court, I prepare for hearings ahead of time, and so I will research the law and I will look up the statutes that apply to a particular hearing that's scheduled before me. And so I keep in mind what the law is, and I will listen for the information that applies to it, as well as other information that may be relevant and may be something that turns the case a different way from maybe the way that I felt heading into it, potentially as far as an outcome. And so even though the cases are not pre-decided when the hearings are set or being held, I do prepare ahead of time and educate myself about what the law is in order to be able to listen for specific information that needs to be presented in order for a particular party to prevail and or for an opposing party to then prevail if it's not presented.
What policies or procedures of county court here would you like to see change, and why?
So when I first took the bench, there were already processes in place. in all of the different dockets, whether it was truancy, misdemeanors, civil traffic, small claims, all of the different dockets that the county judge handles. And I'd like to add that the truancy docket is actually a circuit court assignment, but I specifically asked to handle that docket because I believe in being able to affect hopefully good change in our youth, whether it's through the court system or through outside activities, and educating and being an example to our youth. And so as far as the truancy docket, the school was actually sending a certified letter, and that was how parents were notified of court. And there's a whole process on the school side as well before a case even comes to court, where there's the letters, the text about your child not being at school, or a message, and meetings with the parents. All of these things are done ahead of court. But the school was sending a certified letter to the parents to notify them of the court date. And once I took over that docket and was appearing in court, and then parents were not appearing in court, I realized that the process needed to be changed or updated and to comply with the statute. And so I created a truancy summons, similar to the delinquency summons that is actually served upon the parent of the child, and that is how they come to court. That is the mechanism now of how they come to court. And the reason that's important is because by receiving the summons, they have now taken possession of that summons, and they're under the jurisdiction of the court to appear. If they fail to appear for truancy court, I can issue an order to show cause for them to appear before the court and show good cause, and or tell me why they should not be held in contempt of court for failing to appear. When it was a certified letter or a letter in the mail telling them to come to court, there really wasn't any enforcement mechanism. And so that is one of the processes that I've updated, and I will continue to work on updating processes that I see that need to be done.
Well, the pandemic taught us about this great thing called Zoom court. Whether you like Zoom or you hate Zoom, and my opinion changes on a daily basis, probably related to that. I think Supreme Court, or the rules of judicial conduct, the rules of court administration may have recently changed effective July 1st to allow people to actually appear in criminal courts for some matters by Zoom. I think that process is going to take some getting used to, because unfortunately people on Zoom don't always remember to mute their line, or they're not always dressed as one would hope they would be dressed if they came to actual court. But I think there are going to have to be some modifications that will have to be made related to, and some guidelines that may be suggested to clients and parties who are appearing by Zoom court, and the professional etiquette that would need to be honored, so that people aren't speaking over each other or talking to children or other people in the background, so that there's a clean record. And so I believe that that's one of the things that I think is going to be a big change in starting July 1st and moving forward. And so certainly something that I would like to help institute. I think that will allow the people who are employed, who have criminal matters, who are coming before the court, not to have to come to court and sit there all day, or half the day waiting on their case to be called. And I think it will also increase judicial economy and efficiency in some manner. Having said that, it will be an adjustment, but I think a lot of people will appreciate that adjustment. I am a big proponent of the swift and timeliness of judicial action. And so I think that if we can allow people to have that opportunity for Zoom court on the things when it's not a sentencing or a change of plea in criminal matters, that it will speed things up, but will also lead to more efficient use of judicial time.
So what about the judicial branch of government, more on a broader level, would you like to see change, and why? Not specifically just county court. This could be like Supreme Court, whether we're talking top Supreme Court or like state level Supreme Court. If there's any policies or procedures in those court systems. Obviously as a county judge, that's not something that's under your purview necessarily, but it's just, part of the judicial system at large, I guess, is more what we're looking at.
So one of the things I think I would like to see changed is basically probably legislative or statutory based. If you look at potential sentencing Judges have a wide range of sentencing opportunities across the board in criminal cases, misdemeanors, and felonies. And I'm not trying to say that a judge's discretion should be taken away, but it is concerning that when you look across the wide range of cases and the potential disparity that is there. So you may take someone, for example, who has a possession of cocaine case in Duval County who may get time served on that at first appearances, and someone in another county where they don't score a minimum number of months in prison, but they're going to prison for 3 years for the same charge. And that's because although our statutory scheme of sentencing gives a bottom of the guidelines, which could be probation or could be a prison sentence based on your prior history, it doesn't cap the top except for the statutory maximum. So for a third-degree felony, 5 years, second-degree felony, 15, and then 30 and life, depending on what it is. So I think that in some way leads to this disparity in sentencing and the feeling that people are not always treated equally and the same because there's this wide range of disparity in the sentencing. And a judge has to look at the guidelines, but they also have to consider the facts and circumstances and the mitigation and the other information that is presented to the court at the time of sentencing. But that wide range of sentencing possibilities leads to, I believe, people across the vast wide array of cases feeling as though they've been treated differently than maybe their cohort or someone else who's been charged with the same exact crime. So I think that it would be important if some of the statutory or legislative changes or even the internal regulating of judges themselves led to a way to avoid some of that disparity.
So as far as any type of changes, the Conference of County Court Judges will put forth their agenda in presenting that information to the legislature, whether or not there need to be any type of changes to the laws as well. The conference has the ability to make suggestions or recommendations to the Florida Supreme Court as far as the rules of administration. So I'm not going to express necessarily a particular opinion since it does need to go through our conference in order to basically just be something that we can even speak on it. It has to be more official. I can't have a personal opinion, but I will tell you that I know Ms. Johnson was referring to disparities seen in circuit court. As far as misdemeanors in criminal court, the maximum penalty is up to 1 year, 365 days in jail. And so although there is the possibility, and that is a significant amount of time to be able to take someone's liberty from them on a particular charge and or because of a particular crime that's being committed, I will say that the court has the ability and discretion and should look at multiple factors, and that would be the nature and type of crime that's been charged, the person's criminal history, whether they have any, the wishes of the victim, because the victim has a right to be heard as far as an outcome or sentencing in the case, as well as giving a perspective or sharing how the case or crime has impacted their life. These are all different considerations that as a prosecutor I would take into account in making a recommendation for sentence, and that I still take into account now as a judge. As well, I consider information from the defendants through their defense attorney, and that would be employment, as well as other mitigating factors that may be present. And so I just want everyone to understand that those considerations are being done, and that can also contribute to disparity in sentencing because every case is unique and every person and crime is different.
What is your favorite part of your resume or a professional accomplishment that you are most proud of?
I would probably say that the accomplishment at the law school level, if I may first, was appearing before the Court of Appeals for the Armed Forces. The Court of Appeals for the Armed Forces is a federal appellate court that hears cases from the lower military tribunals. So it's an appeals court, and they are just under the U.S. Supreme Court. So a case may go from a lower military tribunal up on appeal to the U.S. Court of Appeals for the Armed Forces, and then could move to the U.S. Supreme Court in order to be heard. I had the opportunity as a law student to argue on behalf of the United States as an amicus curiae, which is a friend of the court. And so there was a practitioner in New Orleans where I went to law school who guided both myself as well as our brief writer in preparing our friend of the court argument in support of the government's case in that particular case. So I had the opportunity to argue in front of that court at the Fifth Circuit Federal Courthouse in New Orleans. It was a beautiful courtroom. There were JAG attorneys that were all present to hear the argument, and that was very memorable for me as far as my law school career. As far as professional accomplishment, I would say now, at this point in time, is that I have had the opportunity to represent, as a prosecutor, the interests of the state of Florida and victims of crime in over 55 cases brought to trial. And not all cases were cases in which a life sentence would be imposed. Sometimes they were more minor crimes. But any case in which I had the opportunity to present the case to a jury and hold the state, that was my office, to its burden of proving the charge beyond a reasonable doubt, that's very special to me.
So I was very proud to walk across the stage at the University of Florida and receive my law degree. I come from a family who does not have college degrees. I was the first person in my family to graduate from undergraduate and then to go on to a graduate degree. And so I know that my family was very proud of me. And I'm also very proud of my family for the support and the commitment that they gave to me in seeking my degree. I'm appreciative of my community and the education that I obtained here, which gave me the ability to communicate well and to write well so that I could be successful in law school. I graduated a week after I had my first child, so I have to say that receiving my diploma was great, but it was nothing compared to being a mother for the first time. So personally, I'm proud of those accomplishments, but that's not the question that you asked me. Professionally, I'm proud of the fact that I recently celebrated my 24th anniversary of being an attorney, and I started as an assistant public defender on that day. And so I have represented thousands of clients in everything from no driver's license to murder charges. And in doing so, I have had an impact on people's lives. And that's not only the lives of my clients. I have had tremendous impact on victims. I often have victims who would come into our office and speak with us because they felt like the state of Florida was not hearing what they were saying or did not want to hear what they were saying. And I treated them with the same civility and respect that I did my clients. I've had impacts on my clients' family, on the families of victims, on my colleagues and my coworkers. And so I recently received, in July of last year actually, a plaque that said it was thanks for celebrating your 20th year here with the PD's office in the 8th Circuit. And so I'm proud of the fact that no matter how difficult the client is or how difficult the situation is, that I always try to treat people the way I want to be treated and to treat them with kindness and civility, because underneath it all, victim, client, defendant, prosecutor, we're all humans and we all deserve to be treated equally and fairly, and that's what I strive to do.
Please describe an ethical dilemma you've faced previously and how you resolved or avoided the dilemma.
So an ethical dilemma that I faced, I had a client who was charged with some significant charges. He was charged with kidnapping, aggravated battery, resisting with violence. And the facts of the case were effectively that he had grabbed a hold of a young lady at knife point and attempted to pull her into the woods. She got away. He ran off. Her husband found him before the officers did and beat him. Probably deservedly so if the facts of the case were true. And then the officers came and he combated the officers, and that's where the resisting with violence came. And so I had to defend this young man, and he was facing significant time in prison. And he was adamant we're going to trial. And so we went to trial, and I defended him to the best of my ability, which was my job. And after the end of all of this, the jury came back and found him only guilty of resisting without violence. So I had done my job, and had done my job better than I thought I was doing my job. Because before I gave the closing argument in that case, I pulled George Nelson, my co-counsel, into the holding cell and said, what am I going to argue here? And George's words to me were, do the best you can. He's clearly probably guilty. So I went out and I did the best I could. Well, when the jury came back and read that verdict, the clerk read the verdict, I remember sitting down in my chair thinking, oh dear God, this guy is going to rape and murder someone in the future, and it's going to be my fault. And then I had to remind myself that I had done my job, and that it was the jury who had held the state to its burden of proof, and that had found him not guilty of those serious charges. And so that was a personal ethical dilemma for me, because I felt like this person may have escaped the consequences of his poor decisions and his actions. But I realized that my role in the system was not to personally judge him. It was to defend him, and that I had done my role whether I agreed with the decision of the jury or not.
So I have always been a person that has strived to do the right thing. I have a good family upbringing and a strong moral compass. And so every day, or maybe every other day, I'll say, there are cases that come before me where the facts are not lining up to the law. And I'll give you a general example, and this happens often in first appearances. So the judge has to find probable cause in order to then set bond, special conditions on a person. If there's not probable cause, then the court must release the person from custody. And that is part of the function of the judiciary. That's a check on the executive branch, because we each have our own duties. Executive enforces, and then the judiciary interprets and tells us what the law is and applies the facts to the law. And so there may be times that there is a particular fact or element in a criminal case that's not contained in the police report. And so whether or not the defense raises the objection to probable cause, I will see that and I will note that. And if they raise the objection, I'll ask the state for their position. If the defense doesn't raise the objection, I will still tell the state, court finds an issue, what's your position? And so the state can either give argument that day, or they can ask for a continuance to supplement the report if there's that additional information. Sometimes the state does that and they'll ask for the additional time, and I will grant that time. If they don't ask for that additional time and make argument, but I still believe it to be lacking, then I will make the finding that there's no probable cause, and I will release the person from custody. I wouldn't necessarily say that it's an ethical dilemma, but it's something that occurs and comes up in the court system often, and I will always do the right thing. And so even if the person has a serious charge, or it might be someone kind of like what Ms. Johnson said in her particular case, someone that may do something later, but you did your job, I did what was right by the law, and the law said to release them from custody, and so I did.
As county judge, if reelected, what would you do to speed up the judicial process?
So right now, I actually have already implemented certain dockets called my lack of prosecution, lack of service, case management dockets for the civil cases. And so this is to address cases that have been lingering in the system without any action on the part of either the plaintiff or the defendant, whether they're represented by an attorney or not. And so I will hold these regular dockets to bring the parties to court and ask them, what's the status of the case, where are we headed, is this ready to be set for trial? And so by doing that, it will prompt either the plaintiff or the defendant to file a motion or to seek some other type of action on the other party's behalf and continue to keep the case moving. So I try to do that as far as the civil docket in managing that caseload and making sure that cases are moving in a timely manner. As well for the criminal docket, every time there's a criminal docket, which is pretty much every week except for trial week, I'm always preparing ahead and looking at cases, looking at how old the case is, considering the nature of the charge, as well as what transpires in court. If I can tell from just some of the interaction between the defendant and the defense attorney that there's maybe not been communication or contact, then I try to hold people to making sure that they are communicating and having those discussions, so that way the case can either resolve by a plea, if that's the way that the case is going to resolve, or I set the case for trial in hopes that that will bring the parties back together as far as the client and the defense attorney, in making sure that they're discussing their options, whether or not it's a plea or a trial. So I am mindful of the speedy trial rule as well. Even if there's a waiver of speedy trial and we go past the 90 days, I'm still mindful of the fact that cases lingering in the system can cause issues, whether that's on the defense side or the state side, for either lack of witnesses, witnesses moving away, memories fading, and or even evidentiary issues.
I think, as Judge Brannan said, that preparation is key. As the cases are coming before you, you need to be looking at the court files, making sure that there's been progress and movement in the case. And when you're looking at the case, you're looking at the nature of the case as well. Is it something as simple as a no valid driver's license, or is it something more serious like DUI or domestic battery? Well, obviously you would expect those types of cases to move at two different speeds, but it is important to have the discussions in court to make sure that discovery is being timely provided by the state to the defense, and back by the defense back to the state if there is defense discovery, and to make sure that the cases are moving more quickly. So I think that that is important in being on top of things and encouraging the parties in your system to communicate with each other and to hopefully reach resolutions, or to file dismissals on cases that, like in the civil side, that are not being properly progressed upon. I believe that one of the things that could potentially assist in speeding up the process would be trying to set those civil cases as quickly as possible to reach some sort of resolution, as well as the defense cases as well. I know currently that on the misdemeanor cases, my understanding is that all of the cases are set for arraignment whether the state has filed on them or not, and I think that that's one of the things that the clerk's office does to sort of keep abreast of all of the cases, and it encourages the attorneys to make filing decisions rather quickly, which when you're dealing with a 90-day speedy trial limit, that's important. So I think that scheduling people, notating at the initial arraignment or case management about how long you think preparation is going to be necessary before the case is ready for trial or for a resolution, and then trying to hold the parties to those particular timeframes is important for the speedy, quick, efficient administration of justice.
Okay.
And may I have just 1 minute?
Sure.
Thank you.
Go ahead.
Thank you.
Okay.
I just wanted to note that in county court there has been a vacancy in one of the attorney positions as well. There was a time period where the prosecutor was also not in court, and so there were other attorneys that were covering court, covering cases, and having been an attorney myself in those shoes, I was mindful of the fact that, yes, cases need to come to a resolution, not only for the defendant, but for the state and the victim, but also to realizing that the attorneys are people and human beings, and there's only so much work that they can do in a day's time, in a week's time, or even over the weekend. So although I would try to keep cases moving, set cases for trial, have cases resolve, I was also mindful of the fact that our system is comprised of people who have their own lives outside of their career, and that although they do the best that they can in their job as well, that I needed to be mindful of the fact that they can't do everything, and so the court needs to accommodate where it can.
How would you describe your interpretation of the Constitution?
So I believe in the original and textualism interpretations of the Constitution. I believe that we need to look at the founders' intent and how the Constitution was written at the time that it was written. I believe that judges have to avoid thinking of the Constitution as a living document, and that they have to exercise judicial restraint. So judges should not be judging things into law. The legislature is the person or the group of body that is supposed to be creating the law, in addition to the Constitution and the Bill of Rights and those other documents. So whenever you're looking at the Constitution as a living Constitution, you run the risk that the judges now are interpreting the Constitution in lines with the current social conventions, and that allows a judge to potentially, not always, but potentially put into play their own personal thoughts and their own personal agenda into the interpretation of the Constitution. So I believe that it's important to look at the initial original intent of the Constitution and applying it to the situations before us.
My judicial philosophy is one of originalism and textualism. And so I do believe that we need to look at the original intent as well as the language that is used, whether it's in the Constitution, if it's in a statute, municipal ordinance. And so if we look at the particular language, and even too in my interviews with the JNC as well as in Tallahassee, I referred back to my 7th grade gifted English teacher who taught us the proper use of commas and apostrophes. And so utilizing that information and that knowledge and making sure that I'm reading the statute plainly, the way that it's written. What is the plain language? What is the definition that's provided for whether it's in a statute or in the Constitution? Then those plain meaning, the plain meaning of the words is what we should be looking at. And so that is my judicial philosophy, is a strict reading of the language and applying the facts to that language.
And I agree. Every word is important. The placements of the commas are important, and it's important to look at that plain language of the statute and applying it to the facts as well as the intent behind the writing. But the language and the original intent is what's important.
Tell voters why they need to fill in the circle next to your name on that ballot.
I am committed to the law, and I am committed to our community. I have shown over the course of, I wouldn't just say my professional career, but my life, that I have genuinely cared about people, cared about our society. I want our society to function, to progress, for people to have good lives, and for us to abide by our government, which is a government of laws. And so when I'm asking you to vote for me, I'm asking you to vote for someone who has built their life and their reputation upon character, integrity, and service. And it's a genuine commitment to those things. Those were part of my upbringing. Those were the examples that I was shown by my parents and by my family. And it's going to make me a little bit emotional, I think, talking about that. But I've always striven to be a person who gives and looks out for others before themselves. One of the things that I am most proud of is some of the outreach programs that I've created, and that would be my Be the Judge booth that I have at festivals and different events around the county, where I showcase the court and make sure people understand that we are a third branch of government and that we are just as equally important as the executive, the governor, the president, as well as the legislative branch, which is Congress and the House and the Senate in Tallahassee. But we are a co-equal branch of government. And so I have loved meeting with adults and children alike at my Be the Judge booth. As well, I have a program called Read with a Judge, where I come out to the schools. I invite teachers to invite me to come to their classes, and I read a book. It's called A Book About Lawyers with Perspectives from the Bench. And then I bring my robe and my gavel. I let the children hold it, tap it, sometimes bang it. And so that has been one of the joys of being a judge right now, is being able to have those programs and have that interaction with the students and adults.
I love people. I love this community. This is my hometown. I've lived here my entire life. I grew up on a farm in northern Baker County. I understand the value of hard work. I understand the value of ethics and rules. And I value the law. And I value the importance of the law, and that our society needs to follow laws so that we all treat each other with respect, civility, and dignity. In my job as a public defender, I've had to tell people basically for a living that they're going to prison and that the consequences of their actions may be severe. I've dealt ethically and with kindness and compassion with families of the clients, with victims and their families. And I do that because I love people and I love this community. And so I'm not saying that you should vote for me solely because I'm from Baker County and I've lived here my whole life. I'm saying that I deserve your vote because I'm a lifelong resident because I know our people. I know the values that we have. I have similar values. I have a servant's heart. I have served this community my whole life. And I also value and respect the law. And I hope to be able to serve as your county judge and to treat all of you equally and fairly in the administration of clear, decisive justice. And so I humbly ask for your vote. Thank you.